Broadcast is now starting. All attendees are in listen-only mode.
Hello?
Hi.
Hey, Gemma?
Hi, Steve. Looks like we're having a couple issues. If you can hold on for 1 second. All right, sorry about that, everyone. I want to thank you for joining us today. My name is Jenny Faubert, and I'm the editor of Career Education Review. Technology is wonderful, so we had a little issue right there, but we're ready to go ahead and get started. So welcome to our webinar today on 9010 compliance, presented by Ritzert Leyton. As many of you know, or might not know, CER has been published continuously for nearly 90 years. In fact, in January, we will be celebrating our 90th year, and we're very excited about that. What CER does, or what we try to do, is we try to provide information to the career education community through our original articles, our interviews with some of the members of the sector, and of course through our articles on best practices in admissions, academics, marketing, career services, and much more. If you are not a subscriber to CER, I do have a special going on right now for anyone who is new. So if you are interested in becoming a subscriber, please feel free to reach out to me. Now, before I get started and hand it over, I'll just go over a couple of housekeeping things. One, we are recording the webinar, and it will be available on the CER website along with a PDF of the webinar. I'll email that out tomorrow with the link to this information. If you experience any issues during the webinar, please feel free to send me a message through the chat function, and I will try to help you resolve those issues. Last time in our webinar, we did some polls, and we had some really great reactions to that, so we are going to do some polls again. So when a poll comes up on your screen, you can go ahead and select an answer, and then we'll read the answers of everyone, the aggregate answers. Finally, we'll save 10 minutes at the end for questions. So if you have a question, please go ahead and submit it through our question feature, and we'll try to get to everyone's questions, and we possibly may run longer if the questions keep coming in. So with that, I will go ahead and welcome our presenters today, who are Ben Walker and Steve Chema of Ritzert Leyton. I want to thank them and the rest of the team at Ritzert Leyton for their continued support of CER. And with that, I will go ahead and hand it over to Ben to start the presentation.
Thank you very much, Jenny. Is everyone able? Are you seeing this proper screen?
I believe we are.
Okay. Well, this is an important topic. To begin with, we're just going to have a general disclaimer. The views expressed in this webinar and its accompanying materials are those of the speakers, that's myself and Mr. Chema, and do not necessarily reflect the policy for career education review. The contents of this presentation and its accompanying materials do not constitute legal or regulatory advice. No one should act or refrain from acting on the basis of this webinar without seeking individualized professional counsel as may be appropriate. And we're going to talk about, of course, 9010 today. And the question is, why should you care about the 9010 requirements? And really the concern is that this rule applies only to proprietary institutions, and there's some relatively harsh sanctions that occur as a result. Failure to meet the standard, to meet the necessary ratio, for 2 consecutive fiscal years means the school loses its Title IV eligibility. And it loses that eligibility for a period of not less than 2 years. And here is a summary from Easy Audit. This is some pretty new data from June of 2015, and it's given you a general breakdown of what Easy Audit saw in the submissions it received and analyzed. And as you can see, 14 schools had reported greater than 90% of their revenue from Title IV sources for the 2013-2014 award year, and that may differ from a fiscal year, but Easy Audit obviously reports on an award year basis. And so of those 14, some of them may be out of the program if this is their second consecutive year. Others, this could be their first year, which means they've got a little work to do in the next year to make sure that they hit that 90-10 ratio number and are under 90%, so they don't have to have that second year. And what Steve and I noticed when we were analyzing this and taking a look was, a fair number of schools in the 85 to 90% range, which means they should be working on it and implementing some strategies to help them continue to lower their 90-10 number. And a fair number in the 78 to 80% range. 500 out of 2,000, that's about 25%. Are doing a pretty good job of managing their funding and making sure that they're keeping themselves pretty safe. And next, we're going to talk about failure to meet the standard in a single year is going to transform automatically your program participation agreement, your PPA, into one of provisional status for the following 2 years. And provisional status can create some significant problems. One of the things that you must do is obtain prior written approval from the department before you can add any additional locations. And this provisional status can also allow the Department of Education, ED, as we'll refer to it, to revoke the PPA if it determines the institution, quote, is unable to meet its responsibilities under its PPA. And really that's a fairly broad standard and gives the department a lot of leeway in terms of an enforcement action they may take. And so the concern is that once you get on this provisional certification, it gives the department a great deal of leverage and to potentially take enforcement action against you that they might not normally do in the same way, and gives them just a little bit more latitude in terms of what they can do, and especially in terms of revoking the PPA.
Yeah, Ben, and there's, I think, maybe one other point to drive home about that. I don't think you or I want to unnecessarily scare anybody, but the reality is that when you are given a letter that says the department has terminated or has rather revoked your program participation agreement for some reason that falls under that category of you're unable to meet your responsibilities under the PPA, your recourse is essentially to write them back and ask them to change their mind, and failing that, you can take them to federal court and litigate, which is obviously a difficult course and a very expensive undertaking. And this is in pretty stark contrast to what your position is if the department instead has to bring an action to terminate your participation under the regulations, which gives you the right to a hearing on the record in the Office of Hearings and Appeals, and access to a nominally neutral decision maker, still an employee of the department, but nevertheless an administrative judge who's going to call the balls and strikes in that kind of a proceeding, and that is I think much more advantageous for schools that find themselves there than those schools that might be subject to a revocation on the same grounds. So I think really it's one reason to want to try to avoid provisional status.
Absolutely, it becomes a good point, Steve. It becomes a little bit more of the Wild West when the department takes an action on that basis, because as Steve alluded to, the same protections just aren't in place, and the same requirement in terms of process and procedure don't exist. It's a little bit significantly more discretionary on the part of the department. And what have Steve and I seen with regard to the 90-10 rule? We've seen it become increasingly a focus for government investigations, and it remains high on the list for Ed in the context of its program reviews and audits, of course. It's an increasing focus for litigation. We're seeing increasing instances of plaintiffs alleging schools are manipulating their 90-10 calculation and failing to meet the requirement, or that they would fail without having engaged in some form of skullduggery or some bad act.
Yeah, and that is coming in the False Claims Act litigation.
Typically, yes.
Yeah.
False Claims Act cases filed by QTAM plaintiffs, brought on by QTAM, essentially a suit brought on behalf of the U.S. government. And typically who it's going to be in that context is a former or current employee who feels the school is doing something wrong and brings a suit on behalf of the government to recover money. And what occurs is essentially the plaintiff is going to allege that all the Title IV, that you obtained your PPA improperly or retained your PPA improperly. If the government had known what you were doing, it would have revoked the PPA, and therefore every Title IV dollar that has been dispersed becomes a subject of litigation and a demand for damages. And it's just a growing chorus of these types of lawsuits being filed against institutions. It's ever increasing, it seems like.
Yeah, really, in the infancy of these things, you saw it a lot more with things like incentive comp. But like Ben said, we're aware of multiple examples that are pretty recent where, QTAM plaintiffs are looking at 90-10 as, another basis to try to, make some money on these things.
And in some respects, it highlights one of the fundamental problems. This is such a difficult rule to understand. The way it's implemented, the way it's calculated, that oftentimes even the putative plaintiffs don't really know enough to plead it effectively, and so you end up being in a little bit of a morass as to exactly what they're saying went wrong, exactly what their pleadings mean in terms of how the 90-10 ratio was quote-unquote manipulated, and it just it tends to be a messy area of the litigation, I've found at any rate.
Yeah, eventually, you get your chance to show that they don't know what they're talking about, but the problem is that, with the way the pleading requirements are in federal cases, it's pretty easy for these plaintiffs to state a very, nonsensical, illogical, fanciful scenario, and unfortunately, that can get them all the way to discovery in some cases, and that's where you're spending a lot of money and having a lot of conversations with the likes of us.
Absolutely. What else on the 90-10 front? It's a source of reputational risk for the institution. Your 90-10 rates are made public, and you can see the website where you can go look those up. And the 90-10 ratio, when the government implemented it, it's supposed to be an indicator of quality. And so, if your rates are, approaching 90%, 89%, 89.4%, getting up there, it's an opportunity for the media or others to take shots at the school as one that's not providing the quality it should. Whether or not, it truly is an indicator of quality, I think, is a highly debatable point. But nonetheless, it does give the media or others an opportunity to make allegations that, hey, this is not a school worth your time or your money, because look how they're earning their revenues almost entirely on federal funds. Without getting too much into the politics of it, the school ends up facing a little bit of criticism from both sides in terms of the institutional quality on the one hand, and also it's an entity completely dependent upon a federal government on the other hand. So in some respects, you can get caught in a little bit of a vice grip or whipsawed from both sides, depending on which way the particular media outlet leans politically. But we'd like to talk, one question for everyone on the call. How do you manage your revenues to ensure compliance with the 90-10 ratio requirements? It's a source of constant work for our clients, and it's something that schools need to be paying attention to day to day and week to week as they're carrying out their other operations. It's got to be something that's managed carefully, and that you have knowledgeable, experienced people taking a look at it and giving you or the owners of the institution, the operators, the information they need to make sure the school is being proactive in terms of its 90/10 management. And to talk about where does the 90/10 test appear, the regulation is at 34 CFR 668.14B16, and what that regulation overall is doing is recounting and reciting what's necessary for an institution to participate in Title IV programs, and namely that's execute a PPA. And so 90/10 is a really critical and fundamental component to institutional Title IV eligibility. And that's why perceived violations could lead ED, the department, or a key TAM relator in the context of a False Claims Act lawsuit or something like that, to allege all the Title IV funds dispersed have to be returned, in addition to whatever damages and additional penalties may apply. So the fact that it appears as a necessary component of the PPA shows its importance to the department in terms of the regulatory scheme and its importance as for compliance by the institutions. Simply because if you don't comply with it, you can't obtain or retain a PPA. And what does the rule itself require? It requires an institution to, quote, derive at least 10% of its revenues for each fiscal year from sources other than Title IV HEA program funds. And the overall calculation must be included as a footnote to the institution's audited financial statement, which it has to submit annually. You utilize the cash basis of accounting for this purpose, and the institution has an affirmative obligation to report a failure to satisfy the 90/10 requirements to ED within 45 days after the end of the most recent fiscal year. So it's something that auditors are going to be aware of, and it's something the school needs to be aware of to make sure that they are meeting those requirements. And then Steve's going to pick up on the 90/10 discussion of the 90/10 formula itself.
Okay, which is fortunately right here on the screen in front of you. It's best understood if you express it as a fraction, where the numerator of that fraction is a category of revenue called adjusted student Title IV revenue, and that is going to be over or divided by a couple of different categories of revenue. Well, three. Adjusted Title IV revenue, the same thing that the numerator is, plus student non-Title IV revenue, so money that doesn't come from the federal government's student aid programs but is coming from a student. And then this sort of other category of revenue, which we're cleverly calling total revenue from other sources. So you take everything that's in that denominator, divide it into, take the numerator rather and divide it by the denominator, and then you've got your 90/10. Over the years, and you can go forward to the next slide, Ben. As Ben knows, over the years, he and I have spent, I don't think I even want to know how many hours discussing 90/10, what it is, and trying to write about it and explain it to different audiences, whether it's in a court and in litigation, or trying to get the department to understand where a program review finding might be wrong, or in OHA matters. The sum and substance of that wisdom we hope is going to be distilled for you on this slide, which is the critical part of that fraction is really the thing that you can influence and change is really the denominator. And we'd like you to think about that denominator as a cabinet that has two drawers. And in the first drawer, you're going to put your adjusted Title IV revenue from the student and the student non-Title IV revenue. That's what it holds. But drawer one is special in one way. Drawer one can only hold so much of those two kinds of revenue. But you have a second drawer, and the good news is drawer two is infinite in its capacity. It can hold as much Title IV revenue from other sources as you have. So, for example, drawer 1 is going to hold exactly what your total tuition and fees charged is. In this example that we have on the slide, that's $15,000. So think of that as a drawer that can hold $15,001 bills. Now your job as an institution trying to manage successfully its 90/10 is to figure out, okay, where are my sources of revenues and how do I get them into the proper drawer, and how do I get that denominator, that cabinet, to hold enough revenue that whatever is in the numerator isn't going to put me over 90%. Okay, so how do you fill drawer 1? Well, according to Ed's rules, you have to first place the adjusted student Title IV revenue in there. And I've been using this term adjusted Title IV revenue. And what I mean by that is it's kind of like when you're doing your income tax return and you start off with gross income and then you get to hopefully lop off a few things from it, maybe business expenses, educational expenses, and you wind up with something called adjusted gross income. Well, adjusted student Title IV revenue is kind of like that too, because it turns out there are a few things that you can lop off of that gross Title IV revenue number, and we'll get to that. But that goes in there first. That's an idea that we're going to talk a little bit more about later too, called the presumption rule. But that's not the only thing that goes into drawer 1. Drawer 1, of course, still holds your student non-Title IV revenue, so cash payments, for instance, that the student might make, or student loan, private loan payments that the student makes or makes on its behalf. That goes towards your tuition and fees. So that's how you fill drawer 1. But what you have to remember is that that drawer can only equal the total number of tuition and fees charged. So you can wind up in a situation where you've got a whole lot of student non-Title IV revenue, but not enough space in the drawer to put it in. So let's go ahead to the next slide, which I think might provide us with the actual definition for adjusted student Title IV revenue, which is, it's the total Title IV funds dispersed to the student. And here's what you get to subtract, minus the institutional matching funds for campus-based programs, SEOG and federal work study. And you get to subtract any R2G4 funds refunded on behalf of the student. So that's how you get to the adjusted from the gross number. So to illustrate that, if you had tuition and fees for your institution's program at $15,000, and say that the student we're looking at in this instance, because we're kind of doing this on a student by student basis, is $10,000. The student might have received some institutional matching funds, let's say for work study, so that's $500, and this student unfortunately didn't make it all the way through the program, so there was a $250 return to Title IV. Student also got $5,000 in a private scholarship. That is the red herring. Now we put that in there just to make the point that at this point you're not really considering that $5,000 number to figure out what is removed from adjusted or from total student Title IV revenue to get to that adjusted student Title IV revenue. So what you would do is you take that $10,000 gross number. You know that the $500 for federal work study that was from the institution, that was their matching funds, you can subtract that. And you can also subtract the R2T4 $250 return. So $750 comes out. Take that away from $10,000, and voila, you have adjusted Title IV revenue of $9,250. There is also a really critical concept here called funds applied first. Funds applied first are special categories of revenue that consist of, number one, grant funds from non-federal entities or independent private sources. They might be, for instance, if your school is in the state of New York or California or any other state where there is a grant that students may qualify for and could receive to go to school and take one of your programs. That's going to be one category of revenue that is applied first. And applied first means it goes into drawer 1 even before that adjusted student Title IV revenue. Another type of funds applied first are funds from government agency that you or your school has a contract with in order to participate or provide workforce training. So if you have an agreement with your state or county authority that handles, Workforce Investment Act block grants, that money is also in this wonderful category of funds applied first. A third version or category of funds would be, revenue that the school receives that is derived from qualified savings plans for educational expenses, so like your state 529 plans. Finally, you can take, all of that and you get it into that drawer one, plus the, you can also do one other kind of neat thing with it. You can take the sum of those funds applied first, and if you add that to the adjusted Title IV funds that have been dispersed, if the sum of those two things exceeds the tuition and fees, then you get to reduce that adjusted Title IV by the excess amount. And here we're going to try to show you a pretty rudimentary example of what that means. So take your tuition and fees for the program. Again, it's going to be $15,000 in this example. Our adjusted Title IV revenue is $10,000. We threw our red herring in there again. Private scholarships. We're not thinking about that right now because it's not falling into those funds, first funds examples. We've got $5,000 coming from the student, out of their 529 account, and there's also a state grant of $2,500. So you've got a total amount of money here that is, the 10,000 plus the 5,000 plus the 2,500, so a grand total of 17,500. That is bigger than tuition and fees at $15,000. So you're going to get a reduction of that Title IV, that adjusted Title IV revenue to 7,500 from the original 10,000 number. That's what's so great about these funds applied first. Finally, I mentioned the presumption rule. That is, expressly stated that a school has to presume any Title IV funds it disperses on behalf of student will be used to pay tuition fees or other institutional charges, regardless of whether they're credited to the student's account or paid directly to the student. So, it's specified that way, I think, so that, you cannot have the scenario where you're going to disperse directly to the student with a check, the student's going to cash the check and then bring you cash, and you're going to try to treat that as a student payment. That's not going to work. That's Title IV, and it's going to be subject to the presumption rule, meaning they're going to put it in drawer one to cover tuition and fees ahead of actual student cash payments. But as I said before, this presumption applies except to the extent that the student's tuition fees and charges are satisfied by funds applied first. So, those three categories of funds applied first actually work to defeat the presumption. They go into drawer one ahead of your adjusted Title IV funds. And in that, example we were showing you on the previous slide, they might even reduce the number of that adjusted Title IV, which might mean you have a little room left over in the drawer for student cash payments as well. It's a good thing. Okay, so to illustrate just what we meant by applying the presumption, here once again we've got your $15,000 program, and the student is getting $10,000 in Title IV. This time, no institutional matching funds from campus programs, no R2T4. We didn't even put the red herring scholarship money in there, just a $10,000 cash payment. So you've got $10,000 from Title IV and $10,000 from cash. Well, that's $20,000 that, in theory could go into drawer number one. Problem is, drawer number one's only going to fit $15,000 of that $20,000. So what goes in? Presumption rule says all $10,000 of the Title IV, and then the $5,000 that you can fit from the cash payment. The real downside to the presumption rule, right there.
And so what are some 90-10 mitigation strategies? We're going to try to talk about that a little bit through some poll questions and some hypotheticals, because I think those are a better way to illustrate these points than necessarily us just giving lecture. So the first poll question, ABC Medical Institute wants to sell student accounts receivables in order to recognize revenue before the end of the current fiscal year. Knowing that the school will need an additional $75,000 in non-Title IV revenue to be assured of a 90-10 calculation that is below 90%, the school's owner and CEO arranges the sale of the accounts receivable to his brother for $75,000. According to the school's accountant, many of the accounts are seriously delinquent and are probably not worth more than $35,000. Can the school use the $75,000 in proceeds from the sale of AR to achieve a compliant 90-10 calculation? And so we'll do these in real time. Looks like the no's substantially exceeding the yeses, and some number not sure. All right, let's talk a little bit about these accounts receivable. The department's going to disallow sales of accounts receivable when the transaction is not conducted at arm's length. And one OHA case, relatively recent, 2012, is in the matter of Star Technical Institute, and you can see the docket number there, which will allow you to find it if you'd like to. And in that was an appeal to Secretary Duncan, and he reversed the administrative law judge's decision in that case, and stated that he was persuaded that the record contained substantial evidence showing that the sales of receivables from the school to the buyer were structured significantly by considerations other than those expected in arm's-length transactions, and that the requisite conditions of competitive, rivalrous, free market dealings did not exist. As such, no new revenue was generated by respondent, in this case the school's sales of its receivables, and as a result, the purported revenue may not be included as non-federal revenue in the 90-10 calculation. So the critical distinction here is what the department found was there was no arm's length transaction, and it at least initially will take a pretty simplistic view, almost a smell test. Did this proposed transaction pass their smell test? And they see that there was a brother involved in this, the brother of the CEO involved in the sale, and really concluded that it didn't appear to be a payment of fair market value. There was no competitive aspect to it. The brother was not in the regular business of buying accounts receivable or engaging in factoring with other similar institutions or with other similar types of accounts receivable. And so the conclusion reached was essentially that this was this transaction was set up to evade the 90-10 requirements, and therefore the money generated from the sale was disallowed. And so, it's not to say that you cannot sell your accounts receivable and log that as revenue. You certainly can. What you need to make sure of is that the transaction you're proposing to enter into is arm's length, and so you're going to want to review with competent counsel in your state or jurisdiction to make sure that this is truly an arm's length transaction, that it meets the smell test and passes the smell test. And some of the considerations, again, as I just said, fair market value, is the buyer in the normal course tends to buy paper from others in similar situations or for a similar purpose. Did you shop the accounts receivable around so you can show that, hey, I offered them to these 5 people, that this was the entity that gave me the best deal, that's why I went with it. The department would or you would need to convince a judge that that's what you went through to ensure that this was an arm's length transaction. And again, not to say you have to meet every one of those just rattled off, but you want to make sure that your proposed transaction is going to be able to meet some scrutiny by the department. They're not afraid to challenge these things, and they're not afraid to take, at least initially, a fairly simplistic view of it. In this example, I think the mere fact that it was a brother buying them raises red flags for them immediately, and you're going to have to jump through some level of hoops to prove and to show that this was in fact an arm's length transaction merely from a glance at it, because you had a really, what I think the department would consider a related party doing the purchasing.
Okay, so I'm going to do poll question number 2. And in this scenario, we've got a school called the Generic Cosmetology Academy. And what they do is, like most cosmetology schools, if not all, I think all of them have to do this actually, they've got a clinic. And they have students on that clinic floor that provide haircutting, coloring, and styling services that are offered to members of the general public. Students are required to provide these services as part of the school's cosmetology program, and they're supervised by the school's instructors. So, knowing that, can the school count revenue generated from the student performed services in its 90-10 calculation? Okay, I think this was a pretty expected outcome, right, Ben? 83% on yes. A pretty familiar, I think, scenario for folks out there. But let's talk about, why the yeses have it this time. Okay, so in the department's regulation 668-28, specifically in section A3, it provides that institutions can count revenue from activities conducted by it, which are necessary for the education and training of students, as long as these activities are conducted on the campus or at a facility which is under the institution's control, that they're performed under the supervision of a member of the institution's faculty, and they're required to be performed by all students in a specific educational program at the institution. So you have to have all 3 of these elements in order for this revenue to count. But hearkening back to our fact pattern, we've got that. The first thing is that cosmetology schools, this one, the Generic Cosmetology Academy, is operating a clinic floor, and I think everyone rightfully assumed, okay, that means that it's on campus. That's what I meant. Number 2, we say that the school's instructors are supervising this activity. So item number B is met. And finally, it says that this is part of the cosmetology program. So it's part of the curriculum, it's a requirement, it's something they get graded on, and therefore they've made the 3rd element as well. So that is why this should count.
And one thing to add in, or one thought to add, is that this shows the importance of what your syllabus says in your curriculum. You want to make sure that the curriculum is really hitting the high points in terms of what happens in the clinic, and to make sure that you can justify clinical activities in which students are engaged through your curriculum and through your instructional syllabi, so that you can confirm for an outsider or regulator, typically the department, hey, that this is something, the services being provided in our clinic are something that are required by all students in our program. And here in the syllabus is where we cover this component of what's done actually performed in the clinic.
Right, and I think cosmetology schools kind of get a break in one way, because most state statutes that I've looked at, I mean, I think probably all of them, but I hesitate to say all, because who knows, there might be one state out there that doesn't really get into this all that specifically. But what you typically see is that their programs, in order to be approved by the state agency, whether it's a cosmetology board or the state, proprietary school approving agency or whomever, it usually lays out that the program has to be a certain number of hours, and a certain number of those hours have to be practical training where they're doing various types of services. So in that way, you probably have baked it into your curriculum pretty well if you're a cosmetology school. But this isn't, cosmetology schools aren't the only schools out there that get to benefit from what 668-28A3 provides. I mean, you could have a massage therapy program where you've got a massage therapy clinic. Obviously, culinary schools often have restaurants attached to them. You could have auto repair, marine repair kind of programs where students are working on vehicles that the public brings in. And so if you're trying to apply it to your program and you don't have, as Ben said, it isn't altogether crystal clear that they're getting graded for these exercises, that they have to spend a certain amount of time to do it, and that it's mandatory and supervised by faculty. It's a good thing to really analyze your syllabus, your lesson plans, wherever you think this fits in, to make sure that that is out there in very clear form, so that your auditor will be able to justify your inclusion in the calculation, and so that you can use this as evidence should you ever be challenged for including this revenue. Okay, and poll question number 3, Ben, am I taking this one? I think I've sort of gone off script here, but I might as well keep going. So we're sticking with Generic Cosmetology Academy, except this time they're going to count revenues from retail sales of hairstyling products and accessories that are made in that clinic floor. So how about that? Is this going to work? Can they use that that revenue as well? Okay, here we've got a pretty good divide. We've got 30% saying yes, they can, roughly 2/3, 67% saying no, they can't, and 3% saying we're not sure. This is a tough question, and I think the survey results reflect it. To the 67% who said no, it's definitely I think the conservative or orthodox approach. We can say this much, that the department has gone on record, at least in some ways, with this position that providing revenue from the sales of retail products, shouldn't be included. And in some circumstances, they've come out on they've advanced this argument even when the school in question has provided, I think, very substantial evidence that these activities are in the curriculum, and what that might mean in this example would be if they had a syllabus or a course that taught the ins and outs of retail sales, and if they have testimonials from their program advisory board or their employment advisors saying, look, these retail skills are skills that employers that hire our students expect the students to have. It's actually an important part of the business model, and therefore we want students to be trained, and the school responded to that feedback by implementing that kind of training into its curriculum. In spite of that kind of evidence, we've seen the department and the IG in an IG audit take a position that no, we're still unpersuaded. We think 668-28A3 talks about activities as opposed to these retail sales, and we don't think that they should count. And it's a tough pill to swallow, because I think the regulation as written certainly does provide for that. We'd note that, as far as we can tell, this has never been litigated in any federal court, and I think what we would say is that if you're willing to go that far, we think you might have a reasonable argument based on the regulation. But you do need to know that the department gets substantial deference to interpret its own regulations, as they appear to be doing here. What's interesting is in the cases that we're familiar with, where the department has come out in writing and told us, no, you can't include this revenue, they seem to have done it at least in a fairly cautious way. In the context of the IG audit, that's the Inspector General auditing the financial statements and making a recommendation to the department. The department actually went ahead and in the school in question, they did go ahead and adopt IG's stance on this, and they disallowed the revenue. But the school had other issues and wound up, closing before, this ever got a chance to, go up onto the administrative process or appeal or anything like that. So, there really wasn't, much chance to, get this, adjudicated in front of anybody impartially. In the other instance, it came as part of one of those, denial letters. This time it was not a revocation, but a denial of certification. But the same rules applied in that we had no way to argue directly in the Office of Hearings and Appeals and get that due process. We could basically state our case in writing to the same officers who made the decision for the school participation team, and we could try to persuade them. But this hasn't, you won't find this argument getting made in the OHA, at least not yet. And like I said, there hasn't been anybody who's actually litigated it in federal court. So, there may be a little bit of hope to think that if you took this position and you really were in a position to, back it up, maybe even as much as going to federal court, you could theoretically get some vindication. But I think really, to the 67%, the discretion being the better part of valor, I think it's reasonable to predict that the department really doesn't like to see this kind of revenue included, and that you can expect a battle, and knowing that you're a little bit the deck is stacked against you, at least procedurally, it may be better not to rely on these funds unless you think you have to.
All right. Poll question number 4. This year, Media and Career College entered into a relationship with a local community bank to guarantee the payment of $5,000 private educational loans to 12 of MCC's students. 1/3 of the students default on their loans in the following year, and MCC has to pay the bank according to its guarantee. What revenue can MCC count in its 90/10 calculation this year? And so while we wait, your 3 choices: 60,000, 40,000, or none of it.
Yeah, it's a kind of a dense fact pattern, so we kind of made you pull the trigger pretty quickly. But I appreciate everybody who did. What do we have here, Ben?
Looks like we've got 17% saying 60, 43% saying 40,000, and 40% saying none of it. And based on our analysis, MCC's guarantee to the bank makes the private loans full recourse loans. So under ED's rules, MCC could count $60,000 in this current year, but what would happen is it would have to reduce its revenues by the amount of any recourse payments it made in the year in which those payments were made. So the fact pattern was next year, 1/3 of those loans default, and they have to pay the recourse on them. So they'd be able to count 60,000 this year, but next year they'd have to reduce their revenues by 20,000. So it becomes a question of how do you, strategically, what's the best way to manage that money? Can you afford to take the hit in the following year when you set up this sort of a recourse loan situation?
Yeah, and knowing that you may not have perfect information, right? I mean, we don't know when your students are going to default or if they will, and that's, kind of the critical variable here.
Okay. Poll question number 5. MCC decides that it wants to limit its exposure under the guarantee of the bank and changed its agreement to provide that MCC will guarantee up to 25% of the value of each student's loan. Under that agreement, the bank extended $5,000 loans to 20 students. How much of this revenue can MCC count in its 90/10 calculation? Okay. We had 28% saying 100,000, 38% saying 75,000, and 34% saying 25,000. So obviously this is a pretty good question because it elicited a pretty even distribution of responses. And by entering into this agreement, MCC changed, the change agreement makes these loans partial recourse loans. Under the department's rules, MCC may only include the non-recourse portion of the loan proceeds, that'd be $75,000 in the 90-10 calculation, in the year those proceeds are received. So the correct answer would be $75,000 because of the nature of the loans, which is transferred to partial recourse. That is, MCC has guaranteed up to 25%, so there's the partial recourse that's available. So only the non-recourse portion, the 75% remaining, would be allowed to be counted in the 90-10 calculation during the year those proceeds are received. Poll question number 6. MCC's relationship with the bank has been so positive that MCC also turns to the bank to sell student accounts receivable. MCC has $100,000 worth of accounts receivable to sell. The bank agrees to buy the entire portfolio if MCC provides the same recourse amount, 25%. How much revenue can MCC include in its 90-10 calculation this year? And your options are 100,000, 75,000, or none of it. Okay. 17% said 100,000, 59%, 60% said 75,000, and 24% said none of it. Well, what happened was in this case, unlike those private loans, the sale of accounts receivable may not include a recourse provision. So therefore, even though it was only 25%, MCC may not book any of the revenue for the sale of the accounts receivable because of the recourse nature of them. And the concern that raises is that to sell non-recourse accounts receivable of this nature, it's probably going to require a substantial discount to induce someone to purchase it. So it's really the problem that schools face when they're selling their accounts receivable. You cannot include this recourse provision if you want to book it as 90-10 revenue. And so it's the nature of the sale of accounts receivable is just treated differently by the department.
Yeah, it is, and there may be one thing that a school can do to try to avoid this treatment, because the key is, okay, what is it, what is the source of this revenue that's coming in that the school wants to use? If it's from a loan, then you can have some kind of recourse, but if it's just straight AR, recourse can't be part of the equation. So if a lot of schools have, payment plans that, are essentially private educational loans, but to be that, you have to make sure you're following some rules. First and foremost, you need to have done the, Truth in Lending Act disclosures. You need to also make sure that you've got a enforceable promissory note to evidence, the loan. Otherwise, you're not in a position where you've got any way to argue that, oh, no, this is a loan, it's not just AR that I'm selling. And, it's a pretty crucial difference. But that if we were to, incorporate those changed facts, we would get, the loan treatment as opposed to the AR treatment, and that's what allows you to at least, have a recourse situation. Okay, so on to poll question number 7. MCC's CEO and its owner, same person, establishes a scholarship fund by writing a $250,000 check to the school. The school then deposits the check in its operating account and uses that money to award $50,000 in scholarships that year. So can MCC count the $50,000 in scholarship awards as revenue for its 90-10 calculation? Go into that drawer 2. Okay, and here are answers. 67 say no, 30% say yes, and not sure is coming in at a respectable 3%. The no's have it here, and here is why. There are some specific rules that the department establishes that explain when institutional scholarships get the count for Title IV 90-10 calculations. And the guidance says that if you are using revenue that's derived from scholarships provided by the institution as opposed to some other third party, and those can be either in the form of actual cash like this. In this fact pattern, remember the owner actually wrote the check, or it could be a tuition discount applied against the student's account. And those scholarships could be merit-based or they could be need-based. You can do them, but if you want to count them as revenue for 90-10, you have to make sure that the scholarships are dispersed from an established restricted account. And that's where our MCC school went off the beaten path. They put those the $250,000 into their operating account, and then only to the extent that the funds in the account are represented by represent designated funds from an outside source or income earned on those funds. Once again, we fail that condition too, because where did this $250,000 scholarship fund come from? It came from the CEO and the owner, and the department's going to look at that donation and say, well, we really commend you for doing that. We think it's great. It's just not 90-10 revenue because, we think that you make a lot of your money from our money, from the 90-10, and what you've really done is taken your profits, which are largely derived from 90-10, and put them back into the school. That's recycling the money. It's not outside money. If we were to tweak the fact pattern here and talk about something that has, I think, been proposed to Ben and me more than a few times, what if the school establishes a 501c3 nonprofit corporation that is outside the corporation and it's a foundation, and to seed the foundation, it encourages all of its employees to make a donation to the scholarship foundation, and then that foundation can then turn around and award scholarships, and we can even have it in a restricted account because it's going to be the foundation's account, not the school's. So why wouldn't this work? I think the reason it probably doesn't work is that outside source criterion still isn't met. Even though they're your employees, they're individual people with free will, and they may be doing this completely voluntarily, I think the department will skeptically view it as they may have thought this was a condition of their employment, or they may have done it because they thought they would get rewarded, or even worse, what happens if you do have employees who are given a special bonus, and that becomes the source of funds from which they make their donation? I mean, it just becomes
Unmuted.
So for those reasons, employee donations don't seem like a very good bet to beat the outside source requirement.
And the other thing to be conscious of is if you're going to set up a scholarship, make sure that it's done in a fashion that's objective in terms of who's going to get it. Have a committee set up, have a specified application process, make sure that it's open to all students. Every student may not qualify because they may not meet whatever qualifications requirements you want to impose for this to have the scholarship. But you have to make sure that again, the scholarship itself is going to pass that smell test and is going to be perceived as a legitimate scholarship. It's not one person making decisions as to who's going to get scholarships. They're not determined on an ad hoc basis, and it's not viewed as it's not going to be able to be viewed as an inducement to get a student to enroll. Hey, if you enroll, we'll give you this scholarship, and that way you'll be able to pay for your education. And the problem becomes when scholarships are given out on a more informal basis, you can run into potential problems in terms of the legitimacy of the scholarship itself.
Right, yeah, it just doesn't look very good if you've got a certain amount of money that can be allocated to scholarships because it's sitting in this restricted account, and you don't really have much of a basis for who gets it and who doesn't. And so you're kind of awarding this maybe based on need, but you've got more needy students than you would actually need to give scholarships to be safe under 90/10, and you kind of stop once you hit that safe zone. I think that would be the example where the department looking at this with skepticism and implying form over substance type analysis. You might say if this looks like something that was done to get around 90/10 more than it was done to fulfill any purposes that a scholarship might have. Okay, poll question number 8 is about Generic Cosmetology Academy again. And this time they've got a new idea. They want to offer a short program, a 240 clock hour nail technology program, as a way to add a revenue stream that is not connected to Title IV. The school seeks approval from its accreditor for the program, and it starts enrolling students. Can it include this revenue in its 90/10 calculation? Okay, overwhelmingly yes, 78%, and the yeses have it this time. There are, like the additional revenue that you can get from educational activities, there's a number of rules that go to what kind of revenue you can include from non-Title IV programs. And so here are the requirements. It's also found at 668.28A3, and you can include the revenue from non-Title IV programs in your denominator. In other words, you can go into drawer 2 of your cabinet. If the program is approved or licensed by the appropriate state agency, and these are all either ors, or it is accredited by an accrediting agency recognized by the Secretary, or it provides an industry recognized credential or certification, or prepares students to take an examination for an industry recognized credential or certification that's issued by some independent third party. Or you can, if this is a short program that provides training needed for students to maintain state licensing requirements. And finally, or if it provides training needed for students to meet additional licensing requirements for specialized training or practitioners that already meet the general licensing requirements in the field. So if it's some kind of an add-on type thing. In our fact pattern, we said it was accredited by an accrediting agency, by their school's accreditor. And by implication, that's one that's recognized because we know that this cosmetology school is a Title IV school. Otherwise, why would it care about 90/10? The other kind of clue in the fact pattern that it looked like people caught on was that at 240 hours, that's below the minimum length for even a short program to be Title IV eligible. So this was definitely not a Title IV eligible program. Okay, I think we wanted to just say a few quick things about the current regulatory climate and where we are with respect to 90/10. Is this going to change? One thing that has been happening over the last couple sessions of Congress and in the current one as well is that there's been legislation dropped to modify what kind of revenue gets considered to be federal revenue for the 90/10 purposes. What we're showing you here is one such bill, which is in the Senate and was sponsored by Senator Carper, and you can see co-sponsored by a whole host of other senators, many of which are Democratic senators on the HELP Committee for Health, Education, Labor, and Pensions. And this sort of just reflects, I think, what is a pretty committed strategy by some members in Congress to, try to exclude VA benefits, based on some of the negative, stories that, seem to bubble up in the press on a somewhat, recurring basis about, veterans or even, active duty service men and women who are, participating through the GI Bill, somehow getting, a bad deal from their school. So, the concern is that, this might get added in to the reauthorization of the Higher Ed Act. I think and I don't have real current intelligence on this. I don't. Neither Ben or I do a great deal of lobbying on the Hill, but I think that it's much more likely that the threat here is in a larger bill, an omnibus spending bill, or a reauthorization than as a standalone effort. But it's something to keep an eye on because the implications would be pretty severe. I think going back to that chart we showed in the very beginning, we'd see a lot more schools in that danger zone of 85 to 90 if you couldn't rely at all on VA funds to put in your second drawer in that denominator. Additionally, gainful employment is somewhat of a game changer here too. And that's because right now, obviously, the regulation is effective, and we're inside that transitional period where whatever the students' tuition and fees are now could be the basis for this alternate calculation. And so the reason the department did that for the first few years of gainful employment's lifespan is to give institutions the possibility of lowering their debt to earnings ratios by reducing their tuition. So strategically, you may be looking at tuition rates for certain numbers of your programs that you've kind of come to the conclusion might have a gainful employment program. So we're putting this up here just to remind you that you need to also think about the equal and opposite reaction that this will have for 90-10. And we talked about drawer one. If you're reducing the tuition and fees, you're reducing the capacity of drawer one, which might mean that you have a harder time hitting 90-10 if your tuition goes down too much. It's kind of an awful predicament to be in. I think Ben described the regulatory impact of 90-10 as being a vice or a whipsaw, and this is another way that it is. But it's just part of that analysis that you need to keep in the back of your mind. And finally, Consumer Financial Protection Bureau is a federal agency that was created in the Dodd-Frank bill, and it has jurisdiction over private loan programs. And it's exercising that jurisdiction in a couple of ways. I mean, I think they're trying to have the most impact possible, and they go after institutions that are market participants under their authorizing statute, and that usually means the really big ones, and that's why they've brought lawsuits against Corinthian and ITT. But what's noteworthy about what they've been up to is if you look at those complaints that they brought, there are paragraphs where they actually say, we think these lending programs that we're suing these schools for having were predatory. But, and that's not really surprising, but what was surprising is they lay out the theory being that the schools weren't really trying to make, that extra couple of bucks. What they were doing, they were having these loan programs in order to make 90-10, to get loan payments that would allow them to include that as revenue and lower the 90-10 ratio. Which isn't to say that, if you have a loan program, the Bureau is going to be breathing down your neck. I think, they're going to largely look to take out the most egregious, the larger, actors, in terms of these lawsuits. But what you do need to know is they do respond to student complaints, and they have a database and a hotline and an email address, and they are out there beating the bushes looking for students to make complaints. So if you have a private loan program, if that's part of your 90-10 strategy, then just make sure, knowing that these guys are out there, that you're operating it in a manner where students are receiving all the proper disclosures under Truth in Lending, where they understand just as a general matter what the financial obligation is that they're entering into, when they need to repay, what the rate of interest is, that kind of thing. And also, when it comes time to collect, because collection has to be, a part of this strategy, otherwise you don't realize the revenue and you're not lowering the ratio, make sure you're observing all of the requirements for fair debt collection practices. So that means, checking your state statutes to make sure that there are not times when you're calling students to collect from them when you're not supposed to, that you're not, doing anything that might be deemed harassing under those statutes, like, calling their employer to tell them that, you have a debt to collect, that kind of thing. Because, violating those those laws will, number one, expose you to civil penalties under those statutes, generally speaking, but they're also the kinds of activities that lead to complaints that might get the CFPB involved. So keep an eye out for that. Assess those loan programs. Make sure you're not just that you have the policies to do it, but that those policies are being followed through and implemented.
And that really concludes our presentation. We're sorry we ran over a little bit now, but we'll be happy to stick around and take some questions.
Great, thank you. And before I start with the questions, I just want to let everyone know again that yes, we will have the presentation available up on the Career Education Review website, and the recording of the webinar also will be available. I'll send out an email tomorrow with a link to that, so you'll get that tomorrow. Let's go ahead and look at some of the questions we have. The Title IV funds are available to students to cover their tuition. How can an institution require students to use their own funds to pursue the 90/10 compliance?
Okay, well, I guess the first answer is you really can't, require the students to, use Title IV for, living expenses as opposed to tuition and fees, just like you can't really control, the extent to which they borrow, within the allowed limits. But, even if you could, even if you had them, come in with, a suitcase full of cash to pay tuition, that presumption rule is going to get you in the end, because this tuition and fees are going to be presumed to be paid with the Title IV, regardless of how the student actually spends the money. So they kind of have you over a barrel there. The only things that you can really do is to try to explore alternative revenue streams, things to put in that second drawer, and also you can take a look at making sure that you're actually capturing all of the revenue that might cause the adjusted student Title IV to be reduced, and that means making sure you're participating in student grant programs that are offered by states or other third parties if you're eligible, by entering into those contract agreements with state workforce authorities to get those kinds of funds, because any of those things that were on that slide that we described as funds applied first, they defeat that presumption. That's the only weapon you really have against it.
Okay. Are you able to use the remaining tuition and fees charged in a fiscal year and apply to future year for the amount that was limited due to the presumption rule?
Does it carry over? I don't believe it does. I mean, the problem is, remember, as Ben mentioned, that 90/10 is done on a cash basis of accounting premise. So you can only recognize funds as they come in and for the year in which they come in. So you still get the benefit of having those student cash payments on your balance sheet, but the presumption rule can crowd them out of the revenue in your calculation, which is beyond frustrating, I know.
This was in regard to poll question 7, which was the CEO and owner establishing a scholarship fund. Could a board member use his own funds that are separate from the school's account?
What do you think about that, Ben? Yeah.
I think probably yes. I mean, presumably the board member isn't being. I guess it would depend. I shouldn't say yes. It depends.
It always depends.
You would look at what are the source of this board member's funds. Is he being paid a large amount by the school to serve as a board member? If he's doing it as a sort of a public service, a public good, not getting paid for his time, then I would think probably the balance would lean towards yes. Even though he's interested, he's donated his own funds from his own bank account. Presumably the school would set it up in a private account from which it would disperse to students who receive the scholarships. Under that circumstance, I think yes. However, if the board members, primary occupation was serving as a board member for this institution, and that's where he received the bulk of his income annually, or a significant part of his income annually, that would be a more problematic situation. But overall, I think if you look at the circumstances and the amount of being paid to serve on the board versus the amount used to seed the account might factor into the analysis as well. If the amount that the board member receives in payment for his services as a board member is equal to or exceeds the amount used to seed the scholarship, that's probably going to be a negative factor in terms of assessing the degree of separation, I suppose, or independence of the funds used to establish the scholarship account.
Okay, what is a safe range of 90-10 ratio?
Less than 90, of course. A safe range. I'm not sure exactly what you would say, Steve.
Yeah, I think, we talked about, I personally sort of view 85 and up as being kind of in that at-risk category. And, Ben, I'm hoping you'll remember this with me too, because, some time ago, the department announced that it was, concerned about 90-10 rates. I think this was a few years ago, and that it would be more likely to do a focused program review or just have a program review at an institution with an elevated 90-10 rate. And I'm racking my brain right now, folks, trying to remember where, if they said what they thought was elevated. But I believe, if you're somewhere in the high 80s, that's what was going to draw their attention. And so, I think what you're worried about if you're a school in that situation is, I turned in my financial, my auditor passed on the calculation, and we filed an easy audit, and it was accepted, and my 90-10 was 89.7, and so I'm under the wire, I made it, but if the department is going to then take a look at schools that are all in the 88, 89 percentage category and really start to pull apart your calculation, you don't have very much margin for error. And so it's a pretty uncomfortable place to be. And I guess that's where maybe I'd define it, in that sort of high 80s, 87, 88, 89.
Yeah, I think that's probably right. And I think the most important thing to take away is you just don't have much margin for error. If the department wants to take a hardline position, we can't figure out what percentage of your clinic revenues were generated by actual student services. We're going to throw out all the clinic revenues. Suddenly you have a real problem on your hands, and it's becomes essentially kind of a fight for your life, because you didn't have a large amount of margin for error, such that if there was a disallowance, and that's a bit of a strong hypothetical, but it could, the department could take that position. I think it would be unreasonable, but they might. And so then you're really left with having to go to the mat on that one argument that, hey, my clinic revenues are legitimate, here's why. And you just want to, so I think Steve's right that you get under about 85%, you have a pretty comfortable margin. It's that your revenues are going to have to move fairly significantly to start moving the needle up into a problem zone. So, I'm thinking ideally low 80s, a significant goals for that in the chart we looked at for the 13-14 award year. We're in 70 to percentage range, and that's great. They've been doing a great job managing their 90-10 ratios, maybe setting up some short programs to bring in some additional cash, perhaps thinking creatively about what sort of clinical services they might offer. I thought Steve's point about an automotive technician service bay is a great one, and a really creative way to leverage what students need to learn, that is working on automobiles, with a service that the public needs. So I think, I certainly think in response to the question, low 80s is what everyone should be targeting for. And then once you're creeping up to 87, 88, 89, really it's time to think strategically and long range in terms of how you want to deal with the problem.
And I guess I have one more comment on this, which will be a little bit of a plug for us, and will probably make Jenny happy, which is I will do a little bit of more research and address the question of where are you at high risk in our forthcoming article, recapping this webcast, because I do think that there were some statements made historically that I can go back and locate.
And also, I have a comment from one of our attendees who says auditors are required to provide work papers when it approaches 90. Better to stay below 87, or we can be asked for work papers. So that was a comment by one of the attendees.
Oh, very good one.
Yeah, definitely. And so, that is. The only reason the department would want to make that request is that they're going to scrutinize it pretty carefully. So 87, pretty good red line.
Okay. We'll take two more questions. So first one, if students are required to purchase their own textbook or equipment that's not included in the program cost but required for the program, can the student use their Title IV funds to purchase them? And if yes, does it count for 90-10?
Well, yeah, the student can use the Title IV funds, but the funds that they'd be using would be, received by them as part of a credit balance, and that is going to be by definition above this tuition and fees. So I mean, if I understood the question right, the equipment that they're purchasing here is not rolled into the tuition and fees assessed by the school. So you've got the presumption rule that's just going to say that the Title IV that they get is going to go towards every dollar from the first to the last is going to go towards that bucket in drawer one, that tuition and fees number. So it's always going to, the Title IV is always going to count unless you've got a basis to reduce it with some of those first funds categories that we talked about.
Okay, how should dorm and meal fees be counted? Are these fees under the 90-10?
That's up to the institution because it's the tuition and fees that you assess for the students enrollment in the program. So not everything not every fee on the face of the earth gets included in that. I think like library fines, parking fines, failure to return equipment, that kind of or supplies or uniforms, things like that. I think those kinds of charges, which aren't sort of the upfront charges, often are not includable.
And typically the logic is those aren't charges assessed to every student. They become somewhat on a student-by-student basis, whether or not, in the parking example, whether or not I want parking. Not everybody has to have it, so not everybody likely is paying that fee. But if it's a fee or a charge assessed to every student, then it would be count as a tuition and fee for 90-10 purposes.
Great. So that is all the questions we have. If I somehow missed your question, I will make sure we answer it through email. I want to thank Ben and Steve for your time today, and thank you all for joining us. Again, it will be available on the Career Education Review website, and I will send you a link tomorrow with that information. With that, I just want to finally thank everyone again and stay tuned for our next webinar, which I'll be sending out information on that shortly also. Thank you.
Thank you very much. Real pleasure.
Thanks, everyone.